Hello, everyone. You're listening to the Small Business Show. My name is Swire from Garuda Promo, your host for the show. My guest today is Nick Guinn from Gunn, Lee and Cave. Nick assists clients in all aspects of intellectual properties, with an emphasis on trademark and litigation, primarily infringement actions. Nick also prosecutes patents and trademark applications and handles various trademark processings before the U.S. Trademark Trial and Appeal Board of the U.S. Patent and Trademark Offices. Nick is also a practicing professor of intellectual property law and advanced legal writing, and is frequently speak of intellectual property and litigation issues. I have a lot of questions for Nick on this episode, but before that, welcome to the show.
Hey, Swire, thank you for having me. I'm very excited.
Nick, you have a very interesting and impressive background, but wanted to find out more. How did you get into intellectual property, and what brings you to helping client to resolve some of the legal argument about the trademarks?
Oh, thank you, Swire. That's very kind of you to say. I grew up wanting to be a lawyer. There are a few lawyers in my family, and I just always thought what they did was very interesting. And at some point in high school, my parents and I discovered I was pretty strong at math and science, and they encouraged me to study engineering in undergrad. So I studied chemical engineering the entire time wanting to go to law school. And when you go to law school, become a lawyer, if you have an engineering or science background, that opens up a path that isn't open to everyone, and that's to become a patent attorney. To become a patent attorney, you have to have a technical degree or other technical background. And so I took the patent bar exam, as we refer to it, which allows me to help clients protect or obtain patents at the U.S. Patent and Trademark Office. And when you are able to do that, other areas of intellectual property law often present themselves: trademarks, copyrights, trade secrets. And I clerked for a federal judge for a year, but after that, I joined my current firm, and we specialize in intellectual property law, and that's how I got here.
Thanks for sharing. Let's start with some common, I think, mistakes I want to say. And I've been, noticing people's name and logo since our last conversation, right? So what if in the beginning, usually it's the founder's first name or last name will be like Joe Plumbing or Joe Electrician, or even go to like maybe bigger company, Advanced Engineering or Advanced Software, whatever that is. In the beginning, they didn't really think about that. And or as in small business, we don't think about that until we get bigger, until we scale. And now you're getting on the radar for a competitor normally that say, you using my name, you have to stop. Like, how would you advise us to think about that from the beginning?
That's an excellent point, Swire. And there's two related issues there. First, not all trademarks are created equally, and for several reasons. But if we think of trademarks and terms that we use to refer to businesses as falling on a spectrum, we have great trademarks that are highly distinctive. We call them fanciful. Those are made up words like Kodak and Exxon. On the other end of the spectrum, we have generic terms, which can't even function as trademarks. That's like a bag of salt that says salt on it. It doesn't tell you where it came from. It just tells you what it is. And then there's trademarks that fall somewhere in between. And so ideally, if you're picking a name for your company or a product, conventional wisdom would dictate to go towards the fanciful end of the spectrum. Either they're made up words or real words that have nothing to do with the goods and services. So like Apple for computers, Apple doesn't sell produce. Those are great trademarks. The other concern and issue, just as you referenced, is Joe's Plumbing or Anna's Bakery. Sometimes there's such common occurrences, use of first names or use of laudatory terms: the best, advanced, universal. There's these terms that are just so widely used for a variety of businesses that they become weak. Now, using a weak trademark can sometimes actually increase the likelihood, or you may have arguments to make to the Patent and Trademark Office to get your trademark application through if you use a weak term. But the downside is that it's weak because so many people and businesses are using the term that it's going to be extremely difficult to enforce. And between the descriptive marks and these weak terms, two major problems arise. One, you're going to be fighting with your competitors, in terms of customer attention. You may invest money in advertising, but if there's 5 other Joe's Plumbings in town and someone picks up the phone book or more likely goes to the internet and searches for Joe's Plumbing, even if they know your name, they may not call you. They might call one of your competitors or vice versa. That's not good. The other issue is that someone may take issue with your use. They may object and they may send you a cease and desist letter. They may sue you. And now you're in a bit of a bigger pickle, and that can be an expensive fight to deal with. And so picking a good distinctive name is usually the best bet.
So how would you advise us, obviously to pick a name that nobody had thought of before, maybe Yahoo, maybe Google, all right? This doesn't exist before the company, right, with the name. So what about trade secrets? Maybe, in terms of, a company having the trade secret, can it be patented? And I also heard that you have to show your trade secrets, obviously, to get a patent. Like at some point, do the trade secret will release to public after the trademark patent? Is that correct?
So if I hate to say that the different areas of intellectual property law are mutually exclusive, existing in separate silos, because that's not quite right. But if we think of them in these different camps, we've got copyrights for artwork. And I use that term broadly. We use trademarks for source identifiers, names, logos, taglines. We use patents for inventions, and we use trade secrets for secrets. Often there's a lot of overlap and similar flavor between patents and trade secrets. But something that really distinguishes trade secrets from the other areas of intellectual property is what you do with them and how you protect them. You cannot have patent rights unless you file an application with the U.S. Patent and Trademark Office or whatever jurisdiction that you're in. There is no informal or common law patent rights. It's just not a thing. Trademarks and copyrights, you can have rights simply by creating the copyrightable work or by using a trademark. But typically, if you want to perfect your rights, you're going to register your copyrights and your trademarks with the respective governmental agencies. With trademarks or trade secrets, you're not doing any of that. With a trade secret, you need to know what your secret is or what your secrets are, and you need to keep them secrets. If you have to share them with someone, maybe you outsource manufacturing, or you have a contractor that you work with, or maybe even an employee within your company, you're sharing the secrets on a need-to-know basis. If you have a secret recipe and you're a restaurant owner, you probably don't need to share that recipe with someone whose sole job is taking out the trash and cleaning floors, because they probably don't need the recipe. And then similarly, the people that are receiving access to the trade secret information, they're acknowledging the confidential nature of it. So they sign a non-disclosure agreement or take other actions to recognize that they know that these are your secrets and they're going to treat them as secrets. And then you need to treat them as secrets and keep them, maintain the secrecy, whether that's printing them out and putting them in a locked safe or filing cabinet, storing them on a password encrypted computer. You're taking steps to maintain the secrecy. And so as far as your question, Swire, about the overlap or the transition from trade secrets to patents, that's a real thing. It is not uncommon for a patentable invention to start as a trade secret. You have this idea, maybe you've made a prototype, maybe you've prepared some drawings or sketches, and you're thinking, what do I do next? Well, you have an option. You can maintain the secrecy and treat it as a trade secret, or you can file a patent application to obtain patent rights. And even those are not necessarily mutually exclusive. Maybe you hold back on some of the material and keep it a secret, but you disclose other aspects for your invention. You'd probably want to talk to a patent attorney about that to make the best decision for your business. Because maybe there's secrets that wouldn't be entitled to patent protection, but they are valuable to you and your business as a secret. So there's some careful considerations there. But by virtue of filing a patent application, if you go the distance, those secrets will eventually become public information, and you need to be aware of that.
Well, so much to know, and so many ways that we can go there. And I would like to throw more into the mix, right?
Mhm.
So in my business in promotional products, sometimes when I talk to startups or even existing company who are venture out in the new brand, I have to sign NDA to not talk about the logo. But I think a lot of times, and especially for the day of social media, when a brand come out or when a uh, new direction come out from the same company, people will post, wow, your logo looks like another company, that people point those out right away. So how would we advise, or what would be the process for to confirm that there aren't such logo available, or the phrase, right, or the tagline available before spending all the money to design, market it, before it's out on the open market?
Oh, sure. So this is really important for anyone who's looking to start a business or is looking to start a new product line or expand their existing business or product line into a new market or into a new jurisdiction. So talking to the marketing experts, that's a good idea if you have the resources. But it's also important to do a search on your own, and if you can, visit with a trademark lawyer to perform a search to see if there's some viability. So, as I mentioned, you don't have to register your trademarks with the U.S. Patent and Trademark Office to obtain trademark rights. You can file with with your state Secretary of State. Now, your rights are going to be limited to your state, or you also have rights based on common law usage. That is, as soon as you use a name to register your trademark, or I'm sorry, you use a name in business to identify your business, that name has trademark significance. But you perfect those rights by registering. I share those distinctions because that's relevant to how we search. So I'd say the first and foremost thing when searching is looking to see, are there existing registrations or applications on file with the U.S. Patent and Trademark Office or one of the several secretaries of state. And so, our firm has software that makes that search easier to perform and more efficient. And we're not just looking for exact matches. For example, going back to Joe's plumbing, we'd probably want to know if there's Joey's plumbers. That's similar to Joe's plumbing, or at least arguably so. So we're counting for the variations, and we're wanting to search those databases. The other side of it is, if someone is relying on common law rights, they won't necessarily have filed an application or registered their marks with at the federal level or at the state level. But that doesn't mean that they don't have trademark rights, and if you show up, that they're not going to object to your use. And so it would be wise to perform a search on Google or other database, or to search social media platforms to see if there are similar business names out there being used. And while it's not foolproof, because there are businesses that don't have an online presence, they don't use social media, they don't use websites, it's a good start.
Okay. Thank you, Nick. There's so many things that you have to keen account to, and I really wanted to dig deeper, like for protecting the intellectual property rights for a business or a person. So, at what point would you suggest a business to consult a professional like yourself? Is it in the very beginning, or when they start to turn a profit, or really when they receive a letter from someone want to take them to court?
I would say the earlier the better. If someone is serious about starting a business, I think hiring an intellectual property attorney, even if it's for an hour, to consult with them to identify important issues, is a good investment. It's, in the grand scheme of things of startup costs, it's not going to be that expensive, but it can set you on the right path to thinking about next steps. You may visit with an intellectual property attorney, and they may say it's going to cost this much money, and your reaction is going to say, wow, I don't have those resources right now, I can't pay for that. Well, then ask the attorney, okay, can we prioritize the action items? If I can budget X number of dollars per month, what actions should we take and in what order? And I think that's probably getting the best of both worlds, because the reality is that we know business has an unlimited budget, and certainly not a business that's coming right out of the gate. And so, so most intellectual property attorneys are going to understand that and want to work with you to help find a solution that fits. But I think earlier is better. Clients often contact me either at the outset when they're starting their business, which is good, or they've been in business for 10 or 15 years, or at least several years. And I ask what happened. And because they've received a cease and desist letter or been sued, or vice versa. They discover someone is knocking them off or creating problems. They want to know what they can do about it. Those problems could have been avoided or maybe mitigated, perhaps if they visited with an attorney early on in the process.
Yeah, I think on the second case, and especially I have a client before they have their intellectual property rights. Usually they're in some form of manufacturing. So, and obviously they have to outsource their manufacturing to a third party or even overseas manufacturer. And they found that there are knockoff or there are more product that are available now because that company actually they, let's say they order 1,000, they actually run 1,500, and then they're using that 500 to sell at their own profits. Can this be avoided, and what sort of precaution that you would suggest for something like this to happen?
To avoid having to pay someone else for the profits that you've made from the business,
or to make sure that they don't do that, and then obviously they found out, then it's too late. They run a simple example would be like a concert T-shirts. When you go to a concert or a ball game, you always see that before you go into the stadium, and then people will be selling the same T-shirt, same identical printout, and that there are print shop that skimming them, or when
right.
It comes to like a manufacturing place, and even tennis shoes, for example, they actually will overrun them and to actually sell it. Are there ways that we can avoid this to happen?
So if your concern is, as a business owner, is that someone might be knocking off your brand, selling infringing products, there's a couple things. One, protecting your trademarks, protecting your copyrights, in general, just protecting your intellectual property earlier rather than later will go a long way in preventing and or at least making it easier to enforce your rights when the day comes. The other thing is, typically it's a good idea there's exceptions, but typically it's a good idea to take action to stop the infringement when you find out, as opposed to delaying. For one thing, there are legal principles in place that can prevent a plaintiff from stopping a defendant if they wait too long. The idea being, well, you allowed the defendant to do this, they relied on your inactivity, or it's just unfair for you to act now. So you want to avoid that. But second, if you think about the practical side of it, do you think it's going to be easier to stop an infringer or a competitor right after they've started, or if you've given them several years or even several months and they've built some momentum? More likely than not, it's a lot easier to start at the beginning. Oh, I'm so sorry, I didn't realize, or okay, we sunk a few $1,000s into this, we'll just chalk it up as a loss. But when a business is put tens of thousands, hundreds of thousands, millions of dollars into something, they're probably going to dig their heels in a little bit more.
Yeah. We're touching on a lot of gray areas, right? Like, you need the help, but sometimes, you are kind of worried, especially as a small business entrepreneur. Someone will steal your idea, and then now, especially if the competitor or the infringer is bigger than you do, like, would that be a disadvantage if someone who's taking your idea for their own purpose bigger than you are?
Yeah, unfortunately, one of the practical side effects and realities of litigation, or even short of litigation, just disputes in general, is the economic power and disparities between the parties. A bigger party, even if they're in the wrong, knows that for the smaller party to act, smaller parties may have to make an investment in legal fees that may be prohibitive or difficult to pursue. And so the party in the wrong, even if they're bigger, may use that to their advantage. Maybe they compromise, but not as much as they might have to, or maybe they don't compromise at all. And then the flip side is true. Maybe the big company is the plaintiff, or maybe the big company is the one enforcing its rights. But it's a bit of a reach or a stretch in terms of the rights that it's enforcing. But they know because they're the bigger party and the smaller party doesn't have the resources to defend itself, that the smaller party may just capitulate and give up.
Yeah, it's it's so much to worry. You're kind of worrying me now. Like, obviously there are big companies out there, and there's people who do this for that's the business, right? Is to steal idea and to profit from it, or take something that is already manufactured, having a good results, and then they make knockoffs of it. If you go to like Amazon or any online marketplace right now, I can see tons of examples for a similar product, right? That based on a very good idea.
Right. That's absolutely right. And I mean, this is a big issue, that's out there, and it's not going away anytime soon.
Is there hope, or you think that we just have to play smart as a entrepreneur, and like what are really some of the things that you would suggest to protect small business out there?
Yeah, you're right. And Swire, no lawyer, well, let me take a step back. Clients frequently will ask, well, Nick, am I going to get sued, or can I get sued? Unfortunately, that's the wrong answer, because no lawyer is going to say you can't get sued or you won't get sued, because there's frivolous lawsuits.
Mm-hmm.
And sometimes different lawyers have different perspectives on one party's rights relative to another. That said, we can make educated guesses, and we can make prudent or well thought out decisions. So, if you're considering launching a new product line, it's probably worth, or starting a new brand, it's probably worth talking to an IP attorney about the name, the logo you want to use, to see if you're stepping on anyone else's toes, and how broad your rights are going to be, before you invest a lot of time and money into it. Similarly, if you're going to launch a new product, it's probably worth talking to an IP attorney, not only to see how you might protect it, but to see, are there going to be problems with a competitor who sells a similar product? For example, if your business decides to sell a product and maybe it was inspired by someone else's product, mm-hmm. It may be worth going to the attorney and saying, hey, we want to sell this product over here, but we recognize that there's already a product over there. Is that going to be a problem? And these are conversations that they're ongoing. I would say there are plenty of clients who that are maybe transactional in their approach with dealing with me or an IP attorney, where we talk once and or we have one project, that's it. But I think a company that's growing, that's innovative, that's doing interesting things, they're probably going to have an ongoing relationship with their intellectual property attorney as they pursue new opportunities and new ideas evolve.
Yeah, and I think obviously working with you, Nick, then you will be on the lookout for the client. If something happened, you probably with your search can easily find out. Or if you relied on just you being aware of the market, you might like you said, might find out too late, or they're up and running, and then maybe overpass you with their with the knockoffs.
Right. It's not fun giving the bad news, but I'd rather give the bad news than no news. And then the client gets a rude awakening, and they say, well, Nick, or IP attorney, how come we didn't know about this when it seems like something you should have found out about? It's much better to know and to pivot and to make an informed decision.
Yeah, this is a question I want to ask you specifically, in the promotional product industry. Mm-hmm. A lot of times my client would want to do, it usually happens on apparel or a certain name brand item. The client wants to put their logo on a certain name brand jacket, mm-hmm. or on the name brand, let's say a tumbler or something that is a premium, but that company is not in the promotional product industry. Can I just buy an existing item and then put my logo on it to be a co-branding, or what are the rules of engagement for something like that?
So this can be great in terms of what you in your position, Swire, can do there, or someone who hires you to produce promotional materials for them. Mm-hmm. So a couple of things to consider is that one, are there contracts with the company that manufactures the underlying product? So if you're selling a tumbler, whoever manufactured it, does that brand put any limitations in the contract with you that says, we'll sell you this tumbler for $10 or for X number of dollars per unit, but you agree that you're not going to resell it, or you're not going to affix someone else's brand to it? Be on the watch out for that type of language. The other thing is that it's generally not okay to take, let's use Yeti as an example for tumblers. It's generally not a good idea to take a Yeti tumbler, remove the Yeti label, and put someone else's label on it. Now, in the case of Yeti, that would probably be very difficult to remove their logo. But even if it was applying a sticker across Yeti's logo, that's generally not a good idea. Now, the question of having someone else's logo appearing in addition to the Yeti logo or to someone else's logo, that's more of where the gray area exists, and it just depends. But two big takeaways: look out for the contract language to see if you're prohibited from doing anything, and then two, don't remove or cover up the underlying logo.
Yeah, thank you so much for answering the question, Nick. Like I've been trying to really find out the right way to do it because, like you said, some brands are more accommodating for people co-branding, right, with them. They meant for the promo industry, so they want you to buy it. But there are some company, and I would also name Apple's. If you put your logo on Apple and you're not going through the proper channel, like I know their lawyer is going to knock on your door. And if for other product, you can only put the logo on a certain location. So in terms of my industry, there are, like you said, there's a gray area, and sometimes there's some jobs that we don't take on because we know that that's not the right way to use a product. So I think, in my world, for co-branding with your logo, that sometimes you would need, expertise for legal advice as well.
That's absolutely right. And you raised a third strategy point, Swire, and that's knowledge, and knowing the industry, knowing the reputation of the manufacturer. If you know that a manufacturer has a reputation for cracking down on co-branding, that's probably a manufacturer to avoid co-branding with. But and the flip side, if you know that a manufacturer is very amenable to it, they've allowed hundreds of brands to do it, then okay, probably less of a concern. But yeah, knowledge of the industry and who you're dealing with is invaluable.
What are the consequences, if we do that and, their lawyer find out, or it depends on, how big the company is? Because I'm sure that some client, when we say no to them, actually have done it. But, if I'm only doing 5 of them, or versus if I'm doing 5,000 of them, so the impacts will be different. When people go after them, does it depends on what the impact they thought that it made to them, or it depends on, are you selling them, or just you using it, let's say for a dentist they want, or things that are not open up to co-branding and they want to use it, or it really depends?
It depends. The typical lawyer answer, it depends. But something to keep in mind is that as we're talking about branding and co-branding, trademark law, and we're thinking about trademark remedies, and your most common remedy or the recourse that a plaintiff is going to seek in a trademark lawsuit is going to be lost profits. If the plaintiff is doing well, they may not be able to show how much money they've lost because of the defendant's conduct, but they may ask for an accounting of the defendant's profits, in lieu of the plaintiff's lost profits. So that's something. An alternative could be a reasonable royalty. What the plaintiff would have earned, or the brand owner would have earned, had they sold the products, or had this activity, had the parties entered into a license beforehand. Those are the more common models, but there's some other things that can arise.
Yeah, thank you so much, Nick. These are the questions that I always want to ask, and I know that we shouldn't do that, so that's why we walk away. But if you really thought about doing that, you got to really listen to this conversation and and find out why I shouldn't do that. So Nick, I know that we're getting into things in area that right now that are really specific to the individual business. For listener who wanted to reach out to you and find out more about how patent and trademarks can protect them, what would be a good way to reach out to you?
So I think saying that some people might enjoy is, especially with respect to trademarks, is that I wrote a book this past year about trademarks. If they want to learn more about that, and I have other content on my website and a YouTube channel about these topics. But as far as the contacting me directly, reaching out to me via email, they can contact me at nick@nickguinn.com. I assume you'll include that in the show notes, Swire. That's probably the best way to reach me.
Okay. Thank you so much for coming on to the show, Nick. That gave me a lot to think about, and you kind of scared me a little bit. But I will include all the information on our show notes so listener can reach out to you for the specific questions. Thank you so much for coming on today.
Thank you, Swire. It's been an honor.